There are two stages to a judicial review claim. The first stage is where the claimant has to seek permission from the court to progress the case. And in essence, that means that when the application is made to the courts, that's going to involve completing a claim form, setting out statements of facts, and also the legal grounds or basis for the claim. A judge will look at that application and will decide on reading the documentation, has this claimant set out an arguable case? If the judge is so satisfied, then the judge will grant permission, and that then enables the claimant to take steps to prepare for the substantive stage. And the substantive stage results in a hearing, and at that hearing, legal submissions are presented by the claimant, by any interested party that might also be affected by the decision, and also by the defendant. So that hearing is a very legalistic hearing. It's not a hearing that's going to involve the parties giving evidence, and sometimes that has to be really explained and clarified. Evidence that's submitted within judicial review tends to be through witness statement evidence. But the substantive hearing, which will often last up to a day, or if it's quite complex issues, it could be more than a day, is purely legal submissions. There's a particular process for urgent cases in a judicial review. So if we are consulted by the client who needs to seek an urgent order from the court, for example, if they are at risk of having a crucial care package removed and they'd be left in a very, very vulnerable and serious situation, then we make the application for judicial review. So we apply for permission, but we also make an extra application. We ask for something that's called interim relief, where we set out the reasons why we're asking the court to prioritise the case and to treat it on an urgent basis. So we ask for something called urgent consideration. Depending on what the nature of the claim is, if the claimant is arguing that a local authority, for example, is failing to put provision in place that is under a legal duty to arrange, if the judge is satisfied that that's the case, then the judge can make an order requiring that public body to put that provision in place so that it is actually then complying and meeting its legal duties towards the individual. Another very significant remedy in terms of judicial review is something called a declaration. One type of challenge that can be brought by claimants is if they take the view that a policy of a local authority is unlawful. So, for example, if a local authority brings in new policies around how it meets housing needs, or how it's going to allocate resources in terms of making community care provisions available, if it's felt that the impact is going to be unlawful, and this could bring into play issues that come up under the Equality Act 2010. So, for example, if it's felt that the impact of the policy is going to be discriminatory, for example, if the application to court is successful, then a judge could make a decision or make a declaration that that policy is unlawful, thereby requiring the public body to review that policy. Third remedy that might be available is if the claimant is concerned about actions that are being taken by a public body and believes that those actions should stop or not continue. If they're successful in the claim, then the judge can make an order that prohibits the public body from taking those steps. At Irwin Mitchell, we can assist individuals and organisations who are seeking to make applications for judicial review or to intervene. It's an area of our specialisms, and we have individuals who are really passionate and excited about bringing judicial review claims. So we are the organisation to come to. If you feel that you have grounds to seek advice or to bring a claim, please do not hesitate to contact us. We have specialist individuals who are more than happy to advise and assist. And with judicial review claims, time is of the essence. So if you have any concerns and wish to pursue the remedy, please do get in touch with us at the earliest opportunity, and we will do everything that we can to assist.